Good morning, Your Honors. The first matter which I would like to bring up with you on behalf of the plaintiff appellant, Jeffrey's Auto Body, and also, if it pleases Your Honors, I'm also going to be talking about Nick's Garage, the other case which was put on submission. My understanding is we're arguing them together as the cases really were addressed together throughout the process. So, as I believe the court is probably aware from our recent submission, the case on which the trial court relied in finding against my clients on collateral estoppel was recently reversed by the Second Circuit. And they reversed on almost all of the salient points that were relied upon by Judge Murphy here with respect to these decisions. So respectfully, we would submit that as the Northern District of New York decisions, which were relied upon for collateral estoppel, have been reversed in all of the relevant parts, that means that they no longer have collateral estoppel effect, and therefore the judgment should be reversed on that basis. There were a couple of
You weren't necessarily agreeing that there was collateral estoppel in the first instance, but to the extent there's an argument there, you're saying that it's no longer an issue before us.
Correct, Your Honor. And I would say the only 2 points where I would maybe address that would be with respect to the parts that they did affirm with the Second Circuit. That was with the paint materials, which was a very small component of it in terms of dollar amounts. But we would submit that the record was not the same. We actually put in a greater explanation here in the Allstate case to demonstrate why it wasn't merely just a matter of using different systems the way that the Second Circuit found in those cases. Here, what we put forward is we said, look, Allstate in the first instance was just taking a dollar amount times number of hours, and that's how they were calculating paint materials, which habitually underestimated what was required, as evidenced by the fact that they went into, when they would then adjust it to go to the Mitchell paint guide, it was always higher, right? So they were consistently using a formula that underestimated the paint materials.
So except for the paint, and then there was the other claim that the Second Circuit allowed to survive with choice of garages. I don't know if that's in this one, but because the trial court here relied on the federal district court decision, which has now been reversed in Nix, shouldn't it just go back to the district court on all these issues and we don't pass judgment on anything and say, you make a ruling first? Again, the trial court here relied exclusively on collateral estoppel, which doesn't apply, so should we address the merits of them now, or should we just send it back and say, in light of that case, you now do it first?
Respectfully, Your Honor, I would say that the merits were fully briefed below, and they have also been briefed here. So it would seem in the interest of judicial economy, particularly given how long these cases have been pending, to go on and proceed to the merits. But certainly I do understand that looking and asking the trial court to take a look at the merits in the first place is also an appropriate response. So. Because there are those two possibilities, I would like to go ahead and go on and address the merits a little bit if I could. So with respect to the breach of contract claim, I think that it's pretty clear that you're dealing with different accidents, different repairs that were required, and that there are different opinions between the appraisers for the insurance company on the one hand, for Allstate, and then for Nix on the other hand. And in terms of what was put forward, something that I think is persuasive from the Second Circuit decision and which is helpful here, even though they are separate cases, it is separate evidence, but the Second Circuit's discussion of the burden of proof, I think, is also helpful here. Because you can see that in Allstate's brief, even here on appeal, really they're just saying, well, you haven't shown us that it was required, that it was necessary to do all these repairs that you say had to be done for the breach of contract claim. And what we said there, as well as here, because Nationwide and Progressive made the same arguments that Allstate made here, is, look, on summary judgment, that's not our burden.
That's a good argument at trial. That's a good argument at trial that you can't prove your case, but it's
Correct.
Not a good argument if you're the movement on summary judgment.
Correct, absolutely. And I would say that the Second Circuit decision is also helpful in talking about what does a defendant have to do to get summary judgment when they're in this odd position of not being the party that has the burden at trial, but here as the moving party, they are the one with the burden of proof. And it was saying, look, you have to go forward and say, here's where I asked for their evidence and discovery, here's what I got, and this is why it doesn't meet their claims. Allstate didn't do that here. We put forward a lot of detailed evidence. We talked about the credentials of the people doing the appraisals. We have itemized for every single vehicle repair, itemized lists of this is what was needed to be done that wasn't put forward. And then if you combine that with the explanations that were really discussed in the connection with the GBL 349 claim, we talked about how some of these operations, like especially with respect to labor hours, the operations that they aren't allowing were ones which the estimating software says, we're not automatically generating it. You need to go in and manually enter these, because the estimating software, by its own terms, right there in the manual, is done for new, undamaged parts on an undamaged vehicle, which is clearly not the situation you're addressing when you've got a type of collision repair like what all of these were, right? So we put forward quite a bit of evidence that says, here's all of what we have, here's why we think that there's an issue of fact, why we believe that more was required. They didn't do anything, they didn't engage with it at all. They just said, well, you know, it's conclusory, which I find a little difficult to understand how you can describe it that way, given the detail that we put in. But they didn't satisfy their burden, right? And even if they had satisfied their burden, I would submit that we put forward enough on the merits.
You raised a question of fact.
Correct,
Very
correct,
good.
and that it should go to trial. So also with respect to the GBL 349 claim, another area where I think that some of the Second Circuit's reasoning I think can be persuasive for this court had to do with the claim that because they fully disclosed the rate, that there was no deceptive practice. And as we said, again, this is a common theme that we ran into both with those insurers, and it was made here again in the brief to this court by Allstate to say, well, we said what we were going to pay, so there's no deceptive practice. That's not what we alleged. We never said the dollar amount. They lied about the dollar amount that they paid. Yeah, they told us what dollar amount they paid. What we have said is, look, the way that you got to those numbers that you put on the estimate, not just the dollar amount, but also the number of hours, both pieces, right? That's where the deceptive practice lies, because you, Allstate, rigged the system. And in discovery, I really dug deep into it in document discovery and in the depositions to ask questions about how they came to the particular labor rate that they used, and then also with respect to some of the policies and procedures, and this issue with caps on particular types of operations, and again with respect to the fact that manual operations weren't being added to the estimates, even though the guide for the estimating software says you got to go and do these manual operations too. So again, there we went in, really dug down into the methods and said they're habitually doing this. They're systematically doing it. They're doing it repeatedly over and over, and they're doing it in a way that's very hidden. And in case there was any question about that, let's also put forward this evidence about, on a national basis, this program that Allstate had, the core claims process, which was designed, as we put forward in our brief, had as its purpose trying to reduce the severity of claims. So again, there we would say that the Second Circuit correctly said the mere fact that you said the correct dollar amount, that doesn't make it not a deceptive practice. That's not really what we're talking about. We're talking about the methods about how you got to what you put on the page. And again, also the good faith obligation.
Counsel, you should begin to wrap up.
Sure. The good faith obligation, I think, is the same, that they said that doesn't meet the breach of contract claim. So if there are any other questions from your honors?
Thank you.
Yep.